My name is Jessica Saxton. I am a civil rights advocate and litigator from Washington, D.C. I am here to provide notice. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution for the United States is the overarching requirement that every state must follow. I don't think that anyone here would disagree with that. States are not able to enact their own alternative legislation and substitute that for the guarantees of the Constitution. That would mean that your state laws would be more powerful than the Constitution, and that is simply unlawful. Clause 1 of Amendment 5 to the United States Constitution says that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. Unfortunately, the state of Minnesota has enacted a law in its inferior constitution that permits the public officials that you would pay to violate the Constitution. An emolument violation is when you pay public officials to commit a crime. There are two areas of the Constitution that reinforces this. The first is Article 1, Section 10, and that's where it says that no state shall create any law that shall impair the obligation of a contract. So a contract is your police officers, your prosecutors, your judges, your sheriff's department. They are all under a contract. That's a contract to perform based on the oath of affirmation that they took to support and defend the Constitution of the United States of America. So when a state enacts a law and then directs their agents to disobey the supreme law of the land, that would be a violation of Article 1, Section 10. The second area that reinforces the emolument violation is the 14th Amendment, and that's where it says that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. Privileges and immunities of United States citizens are at a minimum, those that are enumerated within the Bill of Rights and the first 10 amendments. These are not able to be impaired. As a result of this, we have an inordinate amount of people that are currently incarcerated here in the state of Minnesota unlawfully and unconstitutionally. Mr. Tanoa Downing is preparing to litigate this at the United States Supreme Court on behalf of more than 700,000 people currently incarcerated across America.
Thank you. Your time is up. Appreciate it. Tanoa Downing.
So my name is Tanoa Downing, and I'm the civil rights litigator that Ms. Saxton was just talking about. I need to provide a little bit of clarification so we can understand what was just said and what we're actually asking from you. So I have approximately 22,000 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment from right here in the state of Minnesota. Many are from within Hennepin County. All right. So again, no state can create its own alternative legislation, go out and enforce that as though it's constitutional. That would be directly unconstitutional. So these, if your sheriff's department, if they're choosing to execute a warrant that's based upon a judge who issued that because they relied upon a prosecutor who abused their power by relying upon an inferior state statute that deprives a person of right that they're guaranteed by the Constitution, that officer's committing a crime, that sheriff's officer, you guys pay for them to do their job. So again, these affidavits, they identify two different crimes. The first is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute says is that any person who, under color of any state statute, ordinance, custom, or regulation deprives any person of any rights secured by the Constitution commits that crime. The second is Title 18 U.S.C. subsection 241, which is conspiracy to deprive rights. What that says is that when two or more persons conspire for the purpose of depriving any person of any rights secured by the Constitution commits that crime. Now, the laws of criminal conspiracy for public officials, what that states is that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of commission of the same, neglects or refuses to do so, may be joined to dispense the action. So upon having been provided with this notice, letting you know that you guys are paying for agents to go out and abridge their constitutional obligations, I'd ask you to please, let's work together to fix this, because the alternative is that I'll have to convert these criminal affidavits into criminal complaints. I don't want to do that. You don't want me to do that. Please don't make me have to do that. So I know that you're going to go and you're going to ask the attorney as soon as we're done whether or not what I'm saying is true, and that attorney is going to point you to a case from 1884 called Hurtado versus California. And before you choose to rely upon that as the foundation, I must remind each and every single one of you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution. That must be done by an authentic act of the people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate. We know that because Clause 1, Article 1 says all legislative power is vested in the Congress of the United States. So I pray that you guys will make the right decision. But just to end it here and to go ahead and entice you guys to make the right decision, United States Circuit Court identifies what an abuse of discretion is, and they say that there's a two-part test. The second part of that test is any erroneous view of the law is an automatic abuse of discretion. An erroneous view of the law would be that in your legal contemplation that the lowest form of law, a judge-made ruling, is superior to the Constitution for the United States of America. That would be an obvious erroneous view of the law. Therefore, if you continue to pay these public officials to commit or abridge their constitutional obligations, that would be, according to the Circuit Court, an erroneous view of the law. Thank you guys so much. I have a notice I need to put on the record, please.